Hello and welcome to the U.S. Update Immigration. Over the past few weeks, many immigrants have been seeing the same word appear again and again across social media forums and private discussions. Leaks claims that USCIS is preparing major immigration reforms for 2026, that internal plans are already finalized, and that sweeping changes are coming without warning. As of December 2025, it's important to slow this conversation down and separate what is real, what has been officially confirmed, and what immigrants should actually prepare for. Because while there is no single leaked memo announcing a dramatic overhaul, there are clear documented signals showing where USCIS and the broader immigration system are heading in 2026. In this video, we'll explain what has really been confirmed so far about USCIS changes heading into 2026, what reforms are already locked in, what policy shifts are being openly discussed inside the government, and what immigrants should realistically prepare for without panic or misinformation. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now let's get into the video. First, let's be clear about one thing. USCIS does not announce reforms through leaks in the way people imagine. Major changes come through published rules, Federal Register notices, budget justifications, congressional testimony, and internal operational updates that later become public. And as of December 2025, several of those signals are already visible. One of the biggest confirmed changes heading into 2026 is cost and access. USCIS has already finalized fee increases that take effect in early 2026, and this is not speculation. These fee adjustments were published publicly and are tied to inflation, staffing costs, and technology upgrades. What this tells us is that USCIS is preparing for higher application volume management, not fewer filings. Historically, when fees rise, the agency also tightens intake review, rejects incomplete filings faster, and reduces discretionary corrections. That pattern has already been visible in late 2025 and is expected to continue. Another confirmed shift is stricter front-end screening. USCIS leadership has openly discussed moving more decision-making to the earliest stages of a case. That means more denials at intake when documents are missing, outdated, or inconsistent, and fewer opportunities to fix mistakes later through requests for evidence. This is not a rumor. Applicants are already seeing this in I-485, I-130, I-765, and employment-based filings. Going into 2026, the expectation inside the agency is faster decisions, but also harsher consequences for errors. Biometrics expansion is another area where facts matter. DHS has already published proposed rules allowing broader use of biometrics for immigration benefits, not just for applicants, but also for certain sponsors and associated individuals. While not all parts of this proposal are active yet, USCIS has begun preparing operationally. That means more fingerprint appointments, more identity verification steps, and potentially longer security-related pauses, even when a case is otherwise approvable. Now, let's talk about digital enforcement, which is one of the least discussed but most important reforms. USCIS, DHS, and other federal agencies are increasing system-to-system data sharing. Tax records, travel history, address changes, and immigration filings are being cross-checked more aggressively than in previous years. This is not new in concept, but it is new in scale. For immigrants, this means inconsistencies that once went unnoticed are now far more likely to trigger delays, interviews, or denials. Family-based immigration is also entering a more documentation-heavy phase. USCIS officials have repeatedly stated that fraud prevention in marriage-based and family-based cases is a priority. As a result, officers are being trained to scrutinize relationship evidence more closely and apply uniform standards nationwide. In 2026, applicants should expect more detailed review of financial commingling, shared residence, communication history, and long-term intent, even in cases that would previously have been considered straightforward. Employment-based immigration is moving in a similar direction. DHS has openly discussed strengthening employer verification, wage validation, and job legitimacy checks. Site visits, employer audits, and cross-checks with Department of Labor data are expected to increase. This does not mean fewer approvals overall, but it does mean employers and applicants will need stronger, cleaner documentation to move smoothly through the system. Another area where rumors often get ahead of reality is green card revocation. As of December 2025, there is no new law or policy authorizing mass green card cancellations. What is happening is increased post approval review in limited circumstances, especially involving long absences, criminal issues, or misrepresentation. That distinction matters. Lawful permanent residents are not losing status arbitrarily, but compliance expectations are becoming stricter. Travel and reentry are also part of the 2026 preparation picture. CBP and USCIS are coordinating more closely, and travelers are seeing longer questioning at ports of entry when records raise flags. This is especially true for individuals with pending applications, prior overstays, or extended travel histories. Again, this is not a new rule, but enforcement consistency is increasing. So, where does the idea of a leak come from? Mostly from internal planning documents, budget language, and training guidance that immigration attorneys and advocacy groups see before formal rollout. These documents do not create new law, but they show direction. And the direction going into 2026 is clear: tighter review, faster decisions, less tolerance for mistakes, and more reliance on data systems rather than officer discretion. For immigrants, the preparation message is practical, not alarming. Make sure every filing is accurate and complete. Use current forms. Match tax records to immigration filings. Keep addresses updated. Maintain strong evidence. Avoid assumptions that this will probably be fine in the system USCIS is building for 2026. Precision matters more than speed. December 2025 is not the beginning of a hidden crackdown. It is the continuation of a visible shift toward enforcement through process rather than enforcement through raids. And that distinction is important. The system is becoming stricter, not through dramatic announcements, but through quiet operational changes that affect outcomes. As we move closer to 2026, more official notices will be published, and we will cover them as they are released. Until then, the best response to rumors is preparation, not fear. The information is already there. It just needs to be understood clearly. That's all we have for this bulletin. The U.S. Update Immigration Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas, such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. If you haven't already, please subscribe to the U.S. Update Immigration channel. Thank you for watching, and we'll see you in the next video.